Thank you. The next one is introduced by Senator Batters.
Thank you very much. So this would amend Bill C-46 in Clause 5A on page 23 by replacing line 35 with the following, colon, quote, 320.27, if a peace officer has reasonable grounds to, and then B on page 24 by deleting lines 18 to 27, and C on page 34 by replacing line 18 with the following, quote, conducted under paragraph 320.27 sub A, semicolon and. So the effect of that is to, the first part of that clause is just to simply change the numbering so that it's correct, and then the remaining parts of it are to essentially remove random alcohol testing for everyone provisions. In weeks of study at this committee, we've seen a mountain of evidence, supplemented today by Professor Stewart, who has significant criminal law background, particularly dealing with the Charter, that this random testing provision is highly likely to violate the Charter and to be found to be unconstitutional. We also heard a lot of testimony that the huge number of court challenges that will occur will exacerbate Canada's criminal court delay crisis. This very committee conducted an excellent comprehensive 18-month study on criminal court delays in Canada. We saw that a glut of impaired driving cases has been a major cause of the court delay crisis, and this crisis has already led to first-degree murderers, those charged with serious sexual assault, serious child assault, having their criminal charges dismissed in the last 18 months. This is the Legal and Constitutional Affairs Committee. It's our duty to provide sober second thought, particularly on these types of constitutional issues. I know we don't want to see many, many more serious criminal charges like murders, sexual assault, serious child abuse cases dismissed because of a massive amount of charter challenges that are brought because of the random alcohol testing provisions in this particular bill. We had criminal defense lawyers with lengthy careers in this field tell us that these provisions would lead to a decade of charter challenge litigation. They called it Christmas. Senator Jaffer actually even described this situation when she was questioning a witness here recently, as she said that if she were still a defense lawyer, she would have a field day with this. So in addition, we have had several witnesses who have cautioned this committee that these random alcohol testing provisions for everyone could lead to a significant level of racial profiling, which would be highly concerning. And so for these reasons, I think that it would be prudent for this particular committee to remove these provisions from the bill.
Thank you, Senator. Senator Gold.
I respectfully disagree. I think the government has made a policy choice in the interest of reducing the harm caused by drunk driving. They've based that upon the experience in other countries and, importantly, on the relative failure of our current law to both detect, deter, and minimize the harm caused to Canadians by drivers who take the wheel after they're drunk. Canadians still, unfortunately, suffer disproportionately at the hands of drunk drivers, notwithstanding all the publicity campaigns to date. It is true that we heard a lot of testimony from lawyers and law professors about the infringements of the Charter that random and mandatory testing necessarily entails. But we also had evidence to the contrary from eminent scholars in their own right who believe, as the government does, that the mandatory alcohol testing is justified under the Charter of Rights. I think we've done our duty as a committee in hearing this evidence, and I'm satisfied that it is sufficient. It has been sufficiently established that there is a credible basis, constitutional foundation for this legislation for us to proceed. And I would think it would be irresponsible for us to pick and choose amongst different experts in order to refuse to pass this important piece of legislation. So I oppose this amendment.
Senator Boisvenu.
Moi, quand je parle aux gens dans la...
Well, when I chat with people in the street and say that we're going to be demanding random tests, that's what we're speaking of, yes? For alcohol, but not for drug, well, could you explain what the logic to that is?
Now is whether or not to remove mandatory testing in alcohol. If we have an amendment before us to consider on drug testing, we'd be happy to discuss it. But I think my argument is simply with regard to the bill as it is, mandatory testing, I believe will survive court challenge, though challenges there will be, as there have been in every time we've changed the law. And I'm satisfied that we have sufficient evidence to proceed to pass the bill without this amendment.
Est-ce que ça veut dire, un exemple, qu'en troisième...
So do you mean, like, for example, third reading on your side, you would accept our putting in an amendment to test the same way on drugs?
We unlike perhaps others, groups in the Senate, don't actually tell each other how to vote. We've taken the position, and I'm pleased to see that you have as well, that we have submitted our amendments here for consideration by the committee. I can't speak to what other colleagues, whether it's in your caucus, independent liberals, or others might do at third reading.
Alors,
So just to explain the logic to me, the logic of the bill, why would we carry out mandatory testing for alcohol use, but not, let's say, for marijuana use? Just what's behind that?
Takes us beyond the discussion of the amendment that's before us, Senator. I'm sure we'll have opportunities to discuss that. The government's position, as it's been provided to us, was that they wanted to take a prudent first step with regard to the introduction of the drug testing regime. We all know and heard that there are differences in terms of the way in which we can predict the impact of cannabis consumption and other drug consumption on driving capacity as compared with alcohol. So I think that there is at least a rational basis for proceeding perhaps in a tap with regard to the new drug offenses as compared with alcohol, with which we have a great deal of experience. But again, we're dealing with a particular amendment which I would not support.
Senator Batters?
As we heard, actually, Professor Stewart say today, other countries that the federal government is relying on, they don't have a Charter of Rights and Freedoms. And that's a significant distinction. And we also heard Professor Stewart say today that in 35 years of charter litigation, since 1982, the Supreme Court of Canada has never justified a Section 8 charter violation as being saved by Section 1, which is Professor Hogg's entire analysis.
Ready to go to a vote? Roll call, please.
L'Honorable Senator Joya CP.
4.
The Honorable Senator Batters.
4.
L'Honorable Senator Boisvenu. L'Honorable Senator Carignan CP.
Pour.
L'Honorable Senator Dagenet.
Pour.
L'Honorable Sénatrice Dupuis. L'Honorable Senator Gold.
Contre.
The Honorable Senator Omivar.
Against.
L'Honorable Senator McIntyre. The Honorable Senator Munson.
Abstain.
The Honorable Senator Pate.
Against.
The Honorable Senator Pratt.
Contre.
Yea 6, noes 5, 1 abstention.
Amendment is adopted. Next amendment, Senator Gold. Senator Munson, c'est abstenu. Oui. 6-5. 6-5-1.
651.
J'ai voté. I have voted.